if mandatory. Then also may come to last paragraph. A posted appointment shall be subject to the final order to be made by the Honorable High Court at petition such and such, filed in Honorable High Court such and such. Last date. Fully filled up application received through registered post such and such be accepted in the office undersigned by such and such date. No application shall be accepted after the date scheduled. Now Lordship may have. Now Lordship may have the affidavit of the secretary in page 284 to 291. This was before the High Court. Not a word on whisper on that. Lordship is completed.
The persons who are holding 2 years diploma.
Yes, 2 years degree.
Or they are D.ed holders.
D.ed.
They have been held to be ineligible.
No, that would
they are D.ed holders.
both prospective and the 70%.
Petitioners were also D.ed holders.
No. We are diploma holders.
They are, no, not my holders.
With that Nios
This scheme. Under scheme.
Program, no diploma.
Nios.
They are concerned, they are D.ed.
Lordship, if they could show the diploma, I am out of the board. It's a program. Distance learning. No 2 years, 18 months. Lordship, I have this.
Degree of education is D.ed, na?
Are you having diploma in education? Are you having diploma in education?
Yes.
D.ed certificate.
Lordship may record it.
We have diploma, but the issue is this is given in 18 months because of the notification, not in 2 years. That's the only difference. So 18 months have been treated on par with 2 years.
How can it be treated as 18 months?
For the reason,
Can you let them complete?
No, you see, High Court says in para 3, the petitioners possess degree of education that is B.ed.
Yes, that's me.
Your petition is
No, I'm not. That's wrong.
Your petition has been dismissed or allowed?
That petition is allowed, and that's why there's a challenge to it. I'm not.
Yes, therefore, these petitioners do not have B.ed.
No, they're not.
High Court says the petitioners possess degree of education.
we are not D.ed one. Or there is a restriction.
Is it right or wrong?
Wrong. Subject to because it's their petitions.
And they have cleared TET, Teacher Ability Test. They have also obtained diploma as recognized by the NCTE in elementary education in ODL mode.
Yes, they are in-house diploma. They are in-house teacher, 18 months diploma. This 18 months includes 6 years training, which otherwise the 2-year diploma holder had to do. That is 2 years plus 6 months training. Vis-a-vis 18 months consolidated.
I'm only asking.
And there is a reason asking
Whether the petitioners before the High Court,
They did not have the degree or diploma.
they did not have the degree or diploma, only 18 months ODL mode.
Program. It is especially called program. Now, Lordship, map page 287. This is the secretary's, the education secretary's affidavit before the High Court. At present, against the advertisement issued for the recruitment for the year 2018-19 and 2021, 70% selection process has been completed. However, the candidature of 21 candidates who are petitioner in the bunch of petition who are having 18 months D.el.ed from NANDAN is considered that situation. The regular D.el.ed training candidates who have already been selected on the which of which the merit decision prepared would have to be amended by the department. In this case, several anomalies would occur. High Court, without there being a challenge to the advertisement first, without asking for any amendment to be carried out, without asking for a press advertisement to be put in the paper. So on the date of the advertisement, the person not being qualified could not have applied. High Court says consider them. On what basis? Now Lordship may have the impugned judgment. It makes very interesting reading, Lordship. Let's have first the program, one-time program, page 18 to 20. What is it all about? Page 18 of the impugned judgment.
The scheme I only been sold for already in service. And there is
page 18. So this is referring to the program introduced. Now, Lordship may skip the part. Lordship may come to page 20, bottom paragraph. This is what the program which my friends, this just Mr. Shukla before the court. These are the persons.
Yeah, because that specifically says that this program shall be only for those in service untrained teachers.
Yes, this is what they have.
So, are they in service or?
They are in service. They are in service persons.
But if they are in service, they are entitled to be protected.
No, they have not been ousted. They are seeking now selection through the advertisement for which they are not qualified. They say he does to be qualified for the press selection.
For the
press selection.
But if they are already in service,
how could they? That is what I am going to the court.
In fact, there are two categories of institutions: private management institutions and government institutions. So this
you are in service in.
We are in service in an institution in question, already working.
No, in private
or government. Private is private.
An employment in government also.
Yes.
How can that be done?
No. No, it is a non-aided institution. This will be aided institution.
So this institution only in order to protect wherever you are protected.
Yes.
Exactly.
That's the idea.
That wherever you are there, you are protected.
Yes.
But then you can't compete with otherwise there will be a competition between non-equals.
Yes.
But the fact of the matter is,
complete quickly.
Lordship may turn to page 37, para 31 and 32. I'm taking the Lordship to the findings of the High Court. That's it.
Page 37.
Page 37, para 31, 32. The High Court is interpreting the way it wants it to be interpreted. On a plain reading, para 31. Of the above provision, it is clear that the preference to notification by the Central Government is not to the minimum qualification, but to the academic authority authorized by Central Government, which is empowered to lay down the minimum qualification to be eligible for the appointment teacher. This is a plain meaning of the section 23 of the Lordship may read that. I will take Lordship to section 21. It is not even the respondent that the NCTE is not authorized to academic authority under section 31 of the Act. The submission learned counsel for the question contrary to observation by the Supreme Court in Shiv Kumar Pathak's case. The minimum qualification has to be laid down by the academic authority authorized by the Central Government and not by the Central Government itself. It is the academic authority which has to be authorized by the notification. Here there is no notification, and the High Court, I will take the court to the finding. No notification required. While holding it, the quoting from the Lordship judgment in Shiv Kumar Pathak's case, it is required to be done by the notification. Lordship may note it. Now, in the next submission of the learned Deputy Advocate General that the recognition of such has not been published in the official gazette. This is very important. Notification. The legislation such and such is not. He submits that the NCTE has already issued notification such as 23(1), which the High Court is running on in the earlier paragraph, laying down the minimum qualification and minimum qualification and teachers eligible to such and such. His submission is that if the minimum qualification have to be relaxed, the same can only be done through a notification published in Gazette. It is thus argued that the second not obliged to take cognizance of order, declaration order such and such, which is binding and enforceable. The notification prescribes the minimum qualification such and such. Learned 2 years. 2-year diploma in elementary education. Now, Lordship may please to turn to page 42. Page 42. Power to relax. This is most important. The one I read out to the court. This is a general power to relax, which is being taken note of in the notification which I read out to the court. It's a general power to relax on the recommendations of the central government.